So good morning, good afternoon, good evening, depending on where you are in the world. And welcome to the ACC Foundation and Lawyers Committee for Civil Rights Under Law webcast, Supreme Court Review, Insights and Implications from the SFFA versus Harvard College and SFFA versus UNC rulings. During this webcast, legal and diversity experts will analyze the potential impact the ruling may have on your organization and business and the corporate legal community at large. I'd like to start by thanking the Lawyers Committee for Civil Rights Under Law for making this webcast possible and for their support of the ACC Foundation. We value this partnership and the amazing work we're doing together to support the Foundation's mission of advancing DEI in the legal profession. Following the presentation, there'll be a time for Q&A. Please feel free to use the webinar chat box to engage one another around the topic. However, if you have questions for the panelists, please enter them in the designated Q&A box, which is different from the chat box. And without further ado, I'm pleased to introduce Damon Hewitt, President and Executive Director of the Lawyers Committee for Civil Rights Under Law. Damon, the floor is yours.
Thank you so much, KJ, and thank you to the ACC Foundation and all of the guests, from your Executive Director, Jennifer Chin, to the ED of the ACC itself. We appreciate this growing partnership with the Lawyers Committee and with all of us in the private bar who care about not just diversity, but also racial equity and, frankly, racial justice. We are clear that last week was a tough week, but we're also clear that we must have a clear analysis before organizations, before corporations start making major moves. We're so pleased that you have come to your home-based ACC and that we've been invited in at the Lawyers Committee to partner to bring you some of the analysis and insights that we have from our fine panel today. Before I introduce the panelists, just want to offer a few framing thoughts of my own, and then I'll intersperse some other thoughts throughout the program. As you have seen in the materials and prep, we're here to talk about the Supreme Court's decision in two important cases: Students of Fair Admissions versus UNC Chapel Hill and the companion case of Harvard University. Two cases that we believe at the Lawyers Committee never should have been up at the Supreme Court in the first place. And in the case of the UNC case, the court granted cert before judgment. The Fourth Circuit never heard the case. We know that case well, the Lawyers Committee. We've litigated both cases since their inception. We're also litigating another case, which we may talk about later at the University of Texas at Austin, even though it should be a res judicata matter based upon the Fisher v. UT Austin cases from a decade and several years ago. Two went up to the Supreme Court. There's another effort at UT Austin, and these efforts probably will not stop. But the court granted cert before judgment in the UNC case. We represent the students at UNC as defendant interveners, which means, of course, in legal parlance, that they had the exact same status as the University of North Carolina. So our lawyers were able to participate in the trial, put on witnesses, experts, cross-examine, and introduce evidence about the fact that the university was advancing a compelling interest and that the plan, we believe, was narrowly tailored to those ends. We also represented students at Harvard with what we call amici plus status. We put on some witnesses at the trial and then had amicus status there on out. So based upon the status that we had in the cases and the work that we've done over the years at the Lawyers Committee, we believe that we helped build a really strong record. And that's exactly what made these cases so dangerous. The Supreme Court took them, because we believe that the likely way that the court could strike down the programs was to overrule existing law. What in fact happened was something that was one of the scenarios we contemplated, but one that many people didn't believe was likely. While claiming to affirm precedent and simply apply it faithfully, especially Bruder, the court actually did not overrule it outright. The court did what we call underruling precedent. It tightened the belt. And what we believe is a very strange application. We believe that it was a tortured interpretation of law, of history, and frankly, of current day reality. The result is that the decision threatens to make higher education less accessible, less equitable, and less attainable for students of color. The court did not overrule Bruder, but it did find that the admissions policies at UNC and Harvard lack sufficient focus and measurable objectives. And so the idea the court found, the majority found that unavoidably these plans read race and used race in a negative manner, going forward stereotypes, and of course, like a meaningful endpoint, which I think we'll talk about a bit, because what is the endpoint to a diversity admissions policy or diversity policy overall? At the same time, the majority wrote that nothing in this opinion should be construed as prohibiting universities from considering an applicant's discussion of how race affected his or her life, be it through discrimination, inspiration, or otherwise. And so that leads us to a really weird result. What type of admissions policy does pass muster under this court's view? And what does that mean for other contexts? Now, we know that many in the business community have been worried about potential fallout from this decision, and we understand that. There are tax abundance. Anytime there is money and opportunity flowing, there are forces who want to see that money and opportunity, frankly, limited in terms of its reach. And we want the exact opposite, and we believe that you do in the audience as well. The question, of course, is what are the implications for you in the business world, in the employment context, and just how do you do it? We're proud of the fight that we waged at the Lawyers Committee along with other allied civil rights organizations. And we know that fight is not over in higher education. Part of the fight, we believe, is helping to bring to you clear analysis and also our strong opinions about not only what may happen, but what you could and should be doing. Joining me for this important conversation are our guests, whom I introduce now. First, my colleague at the Lawyers Committee, Darielle Rodriguez. She's a Deputy Chief Counsel here at the Lawyers Committee for Civil Rights Under Law, where she works closely with me and our Chief Counsel. She manages staff and other paralegals and attorneys to provide strategic guidance on litigation and advocacy projects that advance our mission on racial justice. Darielle most recently served as a political appointee as Chief of Staff at the Office of Federal Contract Compliance Programs at the U.S. Department of Labor in the Biden administration. She previously spent 4 years at the Lawyers Committee as Director of our Economic Justice Project. Welcome, Darielle. Next is my good friend and colleague, Danielle Conley. She's a partner at Latham & Watkins currently. Prior to joining Latham, Danielle served as Deputy Counsel to the President in the Office of the White House Counsel. In that role, she advised President Biden, Vice President Harris, and other senior White House officials on a wide array of legal issues related to voting and democracy, police accountability and justice reform, reproductive rights, tech accountability, and judicial nominations. So she ran the full gamut of issues that we address in the civil rights community. She established and led the first ever White House Counsel's Office team dedicated to civil rights and advancing racial, gender, LGBTQ equity. Danielle also served as the deputy on the Biden-Harris transition team. In a prior iteration, Danielle worked at a different firm where she actually worked on the trial team in the Harvard case. So she knows deeply what she's talking about. She also is a former and hopefully future board member at the Lawyers Committee. Welcome, Danielle.
Thanks, Damon.
Next, our friend Tanya Blocker. Tanya serves as Senior In-House Labor and Employment Counsel for the multinational energy conglomerate National Grid. With over a decade of legal experience in the private and government sectors and a history of litigation victories in both state and federal courts, Tanya provides counsel to the company in its employment law matters and also manages the company's employment-related litigation as well. If you are in any space where people are talking about justice and what corporate America can do, you're probably going to see Tanya, and I'm glad she's here with us today. Welcome, Tanya. And last but not least, a good friend whom I admire greatly, Lexa Kwame Mayers. She serves as Director for Labor, Employment, and Benefits Law at Allstate Insurance Company. She previously served as a Senior Attorney Advisor to an EEOC Commissioner, the person who's now Chair, Charlotte Burrows, representing the EEOC before internal and external stakeholders, including the White House, other government agencies, and advocacy groups on complex equal employment, legal, and policy matters. Before she worked in government or in-house, Lexa also was a civil rights attorney and worker in her own right. We met when she worked at NAACP Legal Defense Fund, where I worked alongside her a number of years ago. I think maybe it was 20 years ago, to date us a bit. And also she worked at Leadership Conference on Civil Human Rights. So welcome, Lexa, to this conversation.
Thanks for having me.
Great. So, folks, I got started with my own recitation of what the case is about, was about. I found it a bit, perplexing and odd that the court issued one decision When the cases were deconsolidated, decoupled, I thought that maybe we get two different opinions, each plan addressing its own merits, which is what ostensibly the court did, but perhaps not really. But we understand at the Lawyers Committee what some of the implications may be for higher education. I think it's also important for us to talk about what the case is not about. For those who have questions, concerns, I'd say even fears about what would happen in the business context, we want to really dig into it. So I want to just open up by asking you all just to give your reactions to the decision, either from a professional or even personal perspective, your perspectives on the ruling. What were your first thoughts about what the ruling would mean for the work that you do?
Damon, again, thank you for having me and having all of us on this panel today. And I really appreciate being part of this important dialogue. I had several reactions. The first, like you and like many, was disappointment. Really disappointed about what we know will be the long-term and expansive impacts of the decision by the court. But I was also inspired by the strong business support. There were over 82 businesses and corporations that signed, I think at least 3 different amicus briefs showing their broadly held support for diversity in higher education and express the impact that has on a diverse workforce and how important that is to the success of businesses. And finally, I feel motivated, right? So I was disappointed, inspired, but I'm now motivated to be even more creative and find ways and creative solutions to continue to provide advice and counsel, not only help Allstate meet its needs, but to partner with colleagues in ACC, to partner with organizations like Lawyers Committee and LDF, continue to think about ways that we can ensure equal opportunity and ensure that efforts around diversity really do meet their needs despite the court's decision. From a personal perspective, I'm also motivated to continue to help with recruiting and interviewing potential candidates at my alma mater at Harvard, and to make sure that all the individuals that I interact with, that their voices, their stories, their complex backgrounds, race will likely be a part of that, is told and is heard.
Thanks, Lexa. And Danielle, you are outside counsel to a number of major corporations doing, I believe, not just litigation, but advisory work as well. So even before you got the calls about what does this mean, you had to be thinking about it yourself. To tell us what your initial thoughts were.
No, I definitely was. Look, I think my initial thoughts were a lot like Lexer's. There was certainly disappointment in the sense of, we've been in this fight for a while in not just showing what the true educational benefits of diversity are, but also just the systemic barriers that students of color often face when it comes to admissions. And the court's decision really did gut some of the, I think, very hard-earned efforts that have been made in this space. A couple of things I will say that to the extent that there were any silver linings, right, is the fact that Justice John Roberts, Chief Roberts, did leave open the idea that applicants can talk about their race and that admissions officers can consider race in the context of other characteristics. So if it shows, leadership or grit or determination, those are still things that a university can consider. And I was optimistic about the fact that the court left untouched the consideration of race neutral alternatives. So continuing to consider things like class and socioeconomic status and your status as a first generation college student and other things like that we know contribute to the diversity of a student body. So, I hate to say it could have been worse, but to the extent that I left feeling a bit optimistic, it was because of that. And then in thinking about the way it sort of impacts just views on DEI initiatives at companies, I was struck by a statement that Lexer's prior boss and our very good friend, Charlotte Burrows, put out the day of the decision, where she said, look, nothing in this case addresses employer efforts to foster diverse and inclusive workforces. And I think that was a message from the EEOC that to the extent that companies have diversity, equity, and inclusion initiatives, it's not the time to take their foot off the gas. I do think that companies need to be careful and make sure that the practices that they are developing are legally durable in light of the attacks that we know are coming on these efforts. But I'm frightened that the decision will act as a chilling effect for companies to really take their foot off of the gas on these efforts, when we know that a part of expanding the pipeline of opportunities for people of color in the workplace is really dependent on these kinds of initiatives. They just have to be done in the right way.
Well, Danielle, that chilling effect is really a serious issue. And I think to all in-house counsel and outside counsel, want you to hear what Danielle's saying on that. I myself have litigated at least parts of every one of the cases that went up to the Supreme Court on affirmative action for the last 20 years. And what we have seen up until now are saves in the court. They tell us we lose both Brad Sandberg and Greer was a winner. They tell us we lose Fisher 1. They say we lose Fisher when it went up again. But we kept seeing saves in the court for 20 years. And then also even before that, since Bakke, we kept seeing saves in the Supreme Court, but almost sabotage on campuses, because admissions professionals that I've spoken to have said, despite the ones in court, there was this sense of inevitability and tightening, right, of the less robust use of race-conscious measures. Now, some were getting more creative, but some were becoming less robust. So what you're saying, Danielle, is critical in terms of chilling effect. Let's not underrule ourselves or overrule ourselves when you have law. Now, let me turn to Darielle and then Tanya in that order, just to talk about why things haven't changed. Has anything about the law of employment that governs employers and their relationships with their employees, has any of that changed? And what does that mean for DEI efforts, if anything? Darielle first.
Thanks, Damon, and really honored to be on this panel with friends and colleagues. Many of you, I deeply admire your work, and am just, as you all said, energized in this moment to work with you all to really double down and ensure that we're advancing equity, not just in higher education, but also in our workplaces, because it's so critically important. So Damon, the ruling was focused on Title VI, higher education admissions specifically. And there was also an equal protection analysis dealing with strict scrutiny. The decision did not impact Title VII, which is the federal law that covers many employers in our country. Title VII of the Civil Rights Act was enacted to ensure that minorities and women in particular had the opportunity to access employment opportunities. And that goal still remains critically important today. And so in the weeks and months leading up to the ruling, we here at the Lawyers Committee did a lot of work. Our Economic Justice Project worked very closely with our education team to ensure that we got the messaging out that regardless of what the ruling was, that it would not impact Title VII. And as Danielle said, I was very pleased to see that Chair Burrows from the EEOC, the day of, put out that strong statement saying that Title VII obligations continue to be in effect, that employers continue to be required to comply with their non-discrimination obligations under Title VII, and that DEI is actually a very effective tool to root out systemic discrimination and to ensure that companies are proactively identifying any barriers in their workplace to remedy them. So the Lawyers Committee will continue to do the work with different partners to ensure that they understand their obligations and that they continue to pursue equity in the workplace.
Yeah, sure. I'll chime in. One, thanking you for the invitation, and it's a pleasure to be on the panel. I'll share with Darielle with friends and colleagues. I'll also just do a slight disclaimer that nothing I say is in the representing my employer, but actually within the confines of my opinion and expertise. I will say this from my personal opinion, and I am going to quote from Justice Sotomayor on how I felt about this decision. The court's invalidation of affirmative action policy cements a superficial rule of colorblindness as a constitutional principle in an endemical segregated society where race has always mattered and continues to matter. And it's just a perpetuation and an exacerbation of that. That being said, that was my personal view when I heard the decision. That being said, I would say all is not lost. I think there's a sense of resiliency here. To Dario's point about whether it impacts employers at all, right? Title VII is still Title VII. It has not been touched by this decision and or determination. Reverse discrimination is something that's also protected by Title VII. I think any employers that in place DE&I policies and initiatives should have in place those with the consideration of potential reverse discrimination claims and made it inclusive. Affirmative action was not to exclude, it was to fulfill the Title VII requirements in protecting all of the protected categories. And that's the way it should be viewed. And when you're viewed as a fulfillment of that law, then yes, you're taking in consideration all aspects, including reverse discrimination. And that does not remove an employer's ability to have focused programs that highlight and heighten the abilities to represent and take into consideration other underrepresented groups and individuals, while still providing opportunities for all employees. So yes, it's a challenge, and I think one that I can see the external environment placing on employers to take the helm at and redefine and affirm that affirmative action is important for ultimately just a right thing to do standpoint, as well as the benefits to the business and the legitimate business reason for enforcing those DE&I perspectives within the workforce.
Thank you, Tanya, and everyone. So we seem to, most of us, be on relatively the same page in terms of our reading of the decision, that there is not a direct implication in the business and employment context. That said, we're in an environment in which we know there are legal attacks on all types of civil rights infrastructure, the statutory infrastructure that was born in the early to mid to late 1960s. We know that there are wars at play for publicly traded companies in terms of proxy fights. There are some companies that have efforts to do racial equity audits and efforts to cancel those very same audits. And so there's all types of pressures the in-house counsel and the C-suite are facing. And there's also just the likelihood of, regardless of what this decision, how it reads, that there are folks on the other side who are, frankly, cause lawyers. They've taken the playbook of the civil rights community and they're bringing test cases and trying to pick and prod. Ed Blum, who created this organization, Students for Fair Admissions, out of whole cloth, is also the same person who brought us the Shelby County Beholder decision, which gutted the heart of the Voting Rights Act. He was very clear. We have him reported on tape saying that he knew he had to find Asian American plaintiffs. He had to go look for Asian American people to convince them that they were being discriminated against, which is not true in our view, and push the case. So we know there will be more challenges, and there will likely be some challenges in the business context. In fact, there may be some underway. Let me actually turn now to Lexer and Danielle in that order to talk about what you're seeing in terms of current challenges and what challenges might you want in-house counsel to know about that may be.
You said it, Damon. I mean, there are challenges underway. It's no secret, for example, that Starbucks was sued just last fall. The directors were sued for Starbucks employing certain hiring goals and tying executive pay to DEI efforts, diversity, equity, and inclusion efforts, diverse suppliers. There have been other charges filed, and this is public information, against other major companies. Charges being complaints of discrimination filed to the Equal Employment Opportunity Commission that investigates claims of employment discrimination. So we've already seen a number of challenges, and I'm sure that there are more. Certainly there are more in the pipeline. Filing a charge with the EOC is part of that. Certainly, companies' ESG efforts around environmental, social governance issues. We've already seen certain attacks and criticisms of companies kind of thinking about their investments under this ESG lens. So there's no shortage at the sort of at the legal landscape, but also legislatively and at the sort of state level. Part of my job is to monitor what's happening at the state level. And we've already seen certain attacks, if you will, on Florida, Kansas, Texas, most recently passed SB 17, which bans the use of race in many different sectors, but particularly employment as well. And so we're going to see, I mean, there's the Supreme Court decision, which is squarely affecting higher education, but there certainly already has been a panoply of legal challenges and state and regulatory efforts as well that are pushing back against companies' attempts to diversify their workforce.
So, I mean, how do you, if you can share in your company, make sense of this? Does it create an environment that is, obviously every corporation wants to avoid liability and manage risk, but can you speak to a pathway that manages risks, but also honors the principles of DEI and the legal requirements of Title VII?
Sure, and I won't speak specifically to what all states' current practices are or what's currently in the pipeline, but just generally things that all companies and organizations should keep in mind that fall under the umbrella of Title VII would be, as I said, keeping an eye on federal and state law, reviewing current DEI communications and measures, doing so under privilege, right? So what's partnering with your human resources department, with your IDE or DEI teams to make sure that communications that go to employees are sensitive to the current rubric and not running afoul of employment discrimination laws. Making sure that decision makers are trained and retrained so that they understand what DEI is and what it's not, right? So it's not tying diversity solely to certain performance goals, and it's not making performance-based decisions just based on someone's protected characteristics. So really ensuring that your workforce understands what the company's priorities are, but also not miscommunicating it such that decision makers, your talent acquisition leaders, your human resources leaders, your directors are not hiring, promoting, demoting, and terminating individuals solely based on diversity goals. There are other things that companies can and should be doing around investing in a diverse pipeline, really looking broadly and creatively, to use that word again, around recruiting individuals, supporting individuals at HBCUs or Hispanic serving institutions. Thinking about tying your diversity and inclusivity metrics towards efforts as opposed to results, right? So not requiring individuals to meet certain specific quantitative goals, but really looking at the efforts that your leaders are taking. There are other examples. I'll stop and let Danielle opine, but there are definitely ways that we can be creative to continue to fulfill the mission of really affirmatively acting to have a diverse workforce.
Thanks, Danielle. Next, then I'll bring Tanya back into the conversation.
Great. I think everything Lexa touched on is just spot on, especially the point about making sure that the people in your HR function and other decision makers, people who are making decisions on who to hire, who to promote, whether to terminate people, aren't using race in making those determinations. And by the way, that's advice any of us would have given you 2 years ago. It has nothing to do with the decision, with the Supreme Court's most recent decision. I do think what the most recent Supreme Court decision will do is put wind behind the sails of a lot of the staunch opponents of affirmative action to challenge these diversity initiatives and to say that certain diversity initiatives run afoul of the court's overall guidance around race conscious measures. But that's all the more reason that you need to make sure that the people who are making these decisions in your function are not using race to make those decisions, unless, of course, you have a Title VII compliant affirmative action program in place that meets all the strict requirements for what an affirmative action program needs to look like in order for you to lawfully consider race and gender as a part of overall decision making. But as a general matter, the use of those protected characteristics in making such decisions weren't permissible 2 years ago or 5 years ago and aren't permissible today. And I think that's one of the most important points to make sure that folks who are looking at these initiatives understand. I think to one of the points that Lexer made, we've seen a lot of challenges. She mentioned the Starbucks case. There have been several demands on boards of directors for having publicized similar diversity initiatives, especially the ones that make diversity goals in a quantified manner. So saying, we're going to hit 25% BIPOC representation on our management or leadership team by 2025. you have to be very, very careful about any quantification of diversity goals in that way, because we've seen so many lawsuits where aggrieved plaintiffs who weren't promoted or who were not hired point to that as evidence that the company was using race as a part of decision making. So again, this is not to discourage having overall goals of increasing the pipeline, of like making sure that you're partnering with HBCUs to get a talented group of diverse candidates in the mix when it comes to people applying into the company or being promoted. But it is making sure that the language that you're using and the direction that you're giving to the people in your HR function aren't compromising you and putting a legal target on your back.
Well, before we move to Tanya, let me ask a follow-up, Danielle. So as outside counsel, when you have a client, current client or prospective client say, hey, we have a policy or a plan, what do we do? Whether they're worried about it or not, they just want some sound advice. Without getting into anything confidential or detail, how do you approach that? Like, what are you asking about outside counsel? And I ask this question because I want the in-house counsel on the call to get a sense of what you should be expecting of your outside counsel, current and prospective.
Yeah, I mean, I think when clients come to me for that kind of guidance and looking at their particular DEI initiatives or programs, one of the first questions I ask are, what are your overall goals? What are you trying to achieve with this particular initiative? And then are there, like, on the spectrum of risk, are there less risky ways to get to the same goals, right? Or is the approach that you're taking right now such that your entire program could come under scrutiny in a way that will cause both reputational harm and legal harm, where you can get to the same result by doing something else? So it's never, I mean, my advice is never scrap your diversity program, scrap this initiative. It's let's look at this. Let's look at the risk. Let's look at the risk tolerance in your organization, because frankly, for some organizations, they'll say, we're really committed to this particular program. We understand that there may be some litigation risk here, but for us, it's important to keep it for the following reasons, right? But other times, the risk threshold of the organization is a lot less than that, or they can achieve the same goals through different measures. And so it's really examining what they've done, what the potential litigation risk is, and whether there are alternate ways to meet the same goals. That is a big piece of what I think Lecture, I'm sure, and Tanya do for their in-house clients, but how we look at these things.
If I may, Damon, Danielle, I'm glad you talked about risk, right? Because ultimately that's what this comes down to. And that's what our job very much entails, all of us, right? Is balancing and managing the risk. And so to your point, scrapping the DEI programs, that's not an option either, for many reasons. One of them being that invites risk as well. It's a double-edged sword, because certainly there's still an obligation to ensure that you're providing an equal playing field and providing opportunities for all individuals to be able to succeed in the workplace. So scratching the programs is not an option. And so we do have to always think about what's our risk tolerance and how are we best going to manage it. We're never going to eliminate all of the risk. Everyone on the call knows that, but it is kind of figuring out what's the right balance to strike. And that's going to vary by company.
If you scrap your programs and then get poor results, then you have some rights folks knocking on your door.
There you go.
That's all the right questions. Tanya.
Yeah, the couple of things I'll add. I think I agree with everything that was already stated. I think I want to hone in on kind of process and application, where you have a race neutral basis for purposes of a DE&I plan. You need to make sure it's applied in the way in which is intended and the application is in alignment with the law. Sometimes it can get easier, right? You may have it race neutral, but when it comes to the application, it can get easier just to fall into, let's just say we want to, employ this number of individuals, and then that satisfies our initiative. We can't do that. So instructions and training on how to apply the appropriately vetted affirmative action plan, I think is important. What we didn't mention, I know we referenced Title VII, but the Office of Contract Compliance and Program of the DOL, the OFCCP, right? As a part of the executive order, there is a requirement that you engage in an affirmative action plan, and there are controls around that affirmative action plan, which is also in alignment, was in place prior to this decision, and you should have been in alignment with that policy and procedure previously for those who are federal contractors And that has not been undone with respect to this particular decision. So I think modeling your plan after those types of processes and requirements in the EEO is a safe space to be in. I think communication is key. How are you advertising your plan, making sure it's rooted in a legitimate business reason for your plan. We didn't also mention kind of the Rooney Rule has not been gutted either from an employment standpoint. And the Rooney Rule speaks to the requirement that at least a diverse individual be a part of the applicant pool for purposes of consideration of a particular role or job. So there are tools that we have available in our tool chest that we can leverage. It just means we need to be attentive to how they're leveraged, how they're applied. We were talking earlier before the session started about, and during the session about kind of litigations that have already taken into place because they saw the writing on the wall with respect to this decision. So BlackRock is a public company that's under scrutiny for their kind of diversity scholarship programs. The Wisconsin State Assembly is also kind of raised some challenges with respect to college grants to individuals of underrepresented communities. So now we're going to start to peel back the layers, and it's about application and how are we applying it. There needs to be fine tuning on that.
Got it. Let me turn back to Darielle. Oh, sorry, someone else said a...
No, I was just going to add one additional point to a point that Tanya made, was that in addition to the challenges we're seeing under statutes like Title VII, Section 1981 is another statute that we're starting to see a lot of reverse discrimination claims challenging these kinds of initiatives come up. And Section 1981 prohibits discrimination on the basis of race in the context of contracting. And there have been court's decisions basically saying that the same standard that applies to the Equal Protection Clause and Title VII is coextensive with 1981. And so it's another sort of statute legal theory to sort of be aware of when it comes to potential challenges in this space.
Let me ask this, maybe you and Darielle, the Comcast case involving Byron Allen, the Entertainment Studios exec, in the ruling about the but-for standard in that case. Does that make Section 1981 challenges against businesses more difficult? Does it change the legal and risk environment, or is it almost the same as it was before? That's questions for you and Derek.
Maybe I'll have Danielle take that one. We did weigh in on the Comcast case by way of amicus brief, and we did argue that raising it to a but-for standard would make it more difficult for litigants, particularly litigants from communities that historically have not had access to counsel to bring those cases. But I'll let Danielle speak from a business perspective.
No, and I do think, but Darielle, it's two sides of the same coin. I do think it'll be more difficult for, even in this context, for allegedly aggrieved plaintiffs to bring those kinds of suits. But at the end of the day, if you're in-house and you're looking at like your legal risk, like the sort of the causation standard is going to probably get through summary judgment, right? And so it is, again, it's about sort of thinking about like what your potential risks are, in this space. Ultimately, you might defeat a suit like that at the end of the day, but you may expend sort of substantial resources defending the case.
Yeah, one thing that I wanted to mention to build on Tanya's comments, but other comments generally. Tanya raised the OFCCP regulations, which require federal contractors and subcontractors to comply with affirmative action regulations. And I think the fact that they're called affirmative action regulations is a little bit, misleading, confusing, because the regulations prohibit the consideration of race or any other protected category when making decisions related to employment. However, those regulations are critically important because I believe the statistic is about 20% of our workforce is employed by a federal contractor, and that's not even including the subcontractors. And what those regulations require is for employers to undertake affirmative efforts to closely review their workforce policies and practices to identify any potential barriers to equal employment opportunity. And where those barriers are identified, to undertake affirmative measures to fix them. And one thing that I've noticed I started my career as a management side attorney, working at an employment boutique firm. And most recently, I was chief of staff to former director Jenny Yang at OFCCP. And one thing that I have seen over and over again is that oftentimes within businesses, the OFCCP affirmative action folks are not necessarily speaking with the DEI folks. And so I think it is really important for both of those teams to be speaking to each other, right? Because you do have the OFCCP folks running a lot of analyses, right? To better understand where there may be potential issues or barriers within their workforce. And that sort of analysis can very well inform the approaches that the DEI team undertakes to advance equity in your workforces.
Thanks, Daryl. Look, we have a number of questions in the chat, and I'm going to turn to some of those right now and ask you all to respond. If there are points you didn't have a chance to make, you can weave them in, hopefully, as I know you're capable of. And I think we have more questions than we actually have time to answer, which is a good and bad thing a bit. So let's go ahead and get started. There's some questions that are about implications and some questions about the decision itself. Let's start with something about the decision. One question, and I'll identify your names if you noted your names in the Q&A, from James Perez. What do you make of the Chief Justice's footnote on military academies' potentially distinct interests? So I guess the question could be twofold. What does that mean in general for higher education, and also what might it mean in the business context? Anyone want to take that? I'll comment. I mean, I think it was Justice Sotomayor or Justice Ketanji Brown Jackson. Response was about how is it good for the bunker but not for the border, right? There's a cognitive dissonance, and frankly, when I think about national security and the government's interests or protecting national security, I think about, hey, this nation is at risk if we don't foster equality, if we have not just, the Kerner Commission, kind of two Americas, one black, one white, but an America where there are people who have opportunity and people who structurally do not, and the people who do not, that often falls along racial lines. I think that is problematic. It's an interesting potential cover out. It's a situation that's actually not presented in the case, but I think it does come from a question asked of the Solicitor General during the oral argument, as I recall. So it's an oddity, and we'll see how that plays out in future case law. What does it mean, not just for the military, but for military academies? And what does that have to say about ROTC programs at undergraduate institutions? I think there's a bit of a question mark, but at the very least, I would say, James, it leaves an opening for future arguments from those who want to see race-conscious decision-making in those contexts.
I appreciate your interpretation, Damon. Part of the pause or the hesitancy on my part to respond is I was thinking about her particular footnote, and I just was thinking about the sort of decades of legally enforced discrimination, particularly in our military, and knowing that for many years and for many battles, people of color were sent to the most difficult battles, if you will. And so just knowing the history of systemic discrimination in our military, I do find it maybe not even ironic, but perhaps unsurprising that that is an area where it is still okay to not have the same, to not put up the same barrier that we're putting in higher education and potentially the workplace. So that was my hesitancy, is that I found the footnote to be particularly on point, and it conjured up some of our painful history.
Thank you. One other question about the decision. An anonymous attendee asked, could you comment on Justice Gorsuch's comments in his concurring opinion where he ties in Title VI? Anyone had a chance to see that part?
Yeah, and Damon, I'm happy to touch on this quickly. I think Justice Gorsuch's concurrence was really focused on the applicability of Title VI because the majority opinion really did its analysis under the Equal Protection Clause and then just said in a footnote that, sort of Title VI and the Equal Protection Clause have the same standards. And so we're going to do our analysis here under the Equal Protection Clause. And so his opinion was a very textualist decision, right? Opinion where he focused on the language of Title VI and why it led to the same result. And there were pieces of the opinion where he brought out Title VII too, to say basically the same, this Title VI mirrors Title VII when it comes to the prohibition of discrimination on the basis of race. And so you can see potentially that coming at us later in the context of an employment challenge in this space.
Right. Let me get to some very specific questions that I think are on the minds of many, or be front of mind at some point when your CEO asks you the question. Angela asks, what impact will this decision have on employers' on-campus recruiting efforts, especially if they have minority internship programs that have historically been promoted on campus, usually with the support of campus administration? What thoughts about that?
I'll chime on that. Oh, go ahead.
No, go ahead. Go ahead.
Okay, I'll only chime on that slightly because that's some of the challenges in the BlackRock case, and also some of the challenges at other kind of institutions. I think one is we have to redefine how we are doing our socialization and recruitment and advertising. I think at the core of that, it is we need to make sure that the language is an inclusive language, reassessing the language, making sure it's an inclusive language with heightened attention towards certain groups. That is how we kind of solve for, as opposed to leaving out that inclusivity language to invite others to participate. So for example, let's say that individuals of a particular social group on campus is the target for, you have law schools that have Black Law Students Association, and that's the target for recruitment for a particular employer. But Black Law Students Association are not limited, right? And they shouldn't just be limited to Black law students. It's anyone that wants to participate and join. So you have allies that may want to join those particular organizations or associations. That means those opportunities for those types of scholarships would be available or should be available for a recruitment standpoint to those allies, so that you have a neutral playing field. Even though you're targeting one particular group, everyone as a part of that group, and DE&I has promoted and continues to promote allyship so that we can all have a level set from an educational standpoint of what individuals of a particular group have experienced. So I think the way in which we do the addressing and recruitment, it's going to matter. How we target that is going to matter. Where we go. Now we know kind of Howard is predominantly, a institution of individuals of color, but not exclusively. So that means what are the programs that they should be available to all individuals with respect inside of Howard, and not just a subset of individuals in Howard. And that's one of the ways we can try to overcome some of those challenges. The other point I wanted to make, which is interesting, and I'm waiting to see kind of how the courts move with this, reverse discrimination claims have been a challenge as a general matter. There are some that have kind of pushed through with respect to in the employment context, but as a general matter, they have not necessarily kind of been, individuals have not been successful. Even if they pass the motion to dismiss, they have not kind of passed summary judgment. I'm curious to see how the courts will now view some of those reverse discrimination claims, and whether they'll have some viability and teeth given this decision.
To that point, I actually share that curiosity, Tanya. EEOC, again, public data in the last decade, they've actually seen a decline in number of charges that alleged discrimination by an individual of the so-called majority versus the minority. So some people call them reverse discrimination cases. So those claims have gone down, but I do wonder if we will see, and I think it's very likely that we'll probably see more creative attempts to be successful at filing charges, and those reverse discrimination claims making their way successfully. Time will tell.
Right.
Thank you. Another question. Sorry, Dariella, did you have another comment on that?
The only comment that I wanted to make, and this is more of like a call to action for companies who are listening in, for in-house counsel, outside counsel, et cetera. One thing that I don't think we've explicitly said is that the ruling will likely have a very direct impact on the composition of student bodies, which will impact the pipeline from which employers recruit, right? And I think for those reasons, employers should not only kind of look to their DEI practices for vulnerabilities, but they should also, as Lexer said, think very creatively about both short-term and longer-term recruitment strategies, right? It may mean that they undertake efforts, as Tanya's discussing, to go out to local colleges and universities to recruit folks from historically underrepresented communities. I think that those kinds of efforts, those longer term efforts, are going to be even more important now.
I agree. I mean, just, snaps all around. I agree with so much of that, because I think what the court's decision left untouched was this idea of race neutral alternatives, like recruiting at HBCUs and HSIs and other, universities that serve students of color predominantly, but not exclusively. And I think that the more and more companies that sort of think about how to form partnerships with those kinds of institutions, that will help build the pipeline in a way that, will hopefully help blunt some of what we think will be the ramifications of this decision.
The terminology is so challenging, and I don't think that hardly any group of people uses it in a uniform way. I think about race neutral sounds, plain on its face, but you think about, for example, like the top 10% plan that University of Texas used at the time. Now it's a bit different. That was race neutral on its face, but it was also race conscious in the sense that it relied upon the sad fact of de facto residential segregation, de facto school segregation, which was driven by de jure school segregation over decades, and also de jure discrimination through redlining. And so it's I think of race consciousness as a spectrum with purely race neutral on one end, and then what you might call a racial preference on the other. Ironically, neither was at issue in the UNC and Harvard cases. There were, despite the rhetoric that was used, the plans did not employ a specific preference for people of one race over the other, nor were the plans purely race neutral. They were on the spectrum of race consciousness. So that's the definition I use, not to challenge anyone on our panel or any of you, but I think it's really easy for us to get lost in the lingo and think you're talking to a colleague about the same thing when people are really talking past each other at times. So be as specific as you can when you're having those conversations inside. Let me turn to another question. Sorry, go ahead, Damon.
No, Damon, I was going to say, but to that point, to identify what I think is another potential risk for companies as they're thinking through these issues, is that even if something on its face is race neutral, if it's done with the intent, right? Like, in other words, if you've got a bunch of emails from your HR folks saying, we know we can't do this anymore, but in order to get more Black people in the room, we should definitely be doing X, Y, and Z, then evidence like that can be, potentially used against you. So you need to be very careful.
I'm glad you asked the question. So here's a question from an anonymous attendee, a blunt question. How do we increase our number of Black and brown employees to get promoted within a company in this climate? We historically had a quote unquote minority mentorship program for them, but we have pulled that back. So let's say that you're in-house, as Lexer and Tanya are, or you're outside counsel, and you receive that question. What do you say?
I need to know what tools you're being used in order to effectuate that type of program, right? What do you have in place? How are you recruiting for individuals on that program? Is it exclusive to only certain individuals of persons of color? I should say. I think we need to kind of dig underneath that particular program and unpack it. And it's not that you have to eliminate it. It's just, to Lexer's point, you have to be creative. It has to be invited to everyone, the way in which you communicate that, right? So let's say you have ERGs, and that's the group that you're going directly to kind of recruit people for that program. Again, ERG should not be exclusive to individuals that identify or have an affinity for that group. It should include allies that are participants in that group. And if those allies apply to that program and want to participate, they shouldn't be precluded from doing so in that particular effort. So I do think, to Danielle's point earlier, and I'll say application. We have everything on its face looking either race neutral, which I agree with you. I don't necessarily like that term. Race plays a part in our lives. The justice's decision to say it's okay for you to talk about overcoming racial discrimination, but we can't talk about race, just doesn't kind of make sense to me in future applications. But be that as it may, that's what it is. So now we need to look at how are we applying these programs to the initiatives and making sure you are bringing the legal counsel in. DE&I and legal counsel should be working very closely together, hand in hand, on some of you and some or most of your DE&I initiatives.
It should be a partnership. I agree with everything that you said, Tanya. First, looking at the tools or resources, and Tanya referenced ERGs. Many companies call them employee resource groups, or some call them employee interest groups. But really, it's a resource, right, for individuals of all backgrounds to be able to share, to provide guidance, to provide training, mentorship, tools and how to navigate a company, large or small. So really making sure that there are resources available to the employees. I think the question asked about promotion. One other thing about terminology, we throw out acronyms, we talk about DEI. I don't want us to lose track of the I and the inclusivity piece, and ensuring, right, being able to be promoted means making sure that you are really included at the table and have the opportunity to be on, projects to give you the exposure in order to be considered when those decisions are being made. I want to point out with respect to inclusivity, a number of states have passed legislation. The Crown Act, which looks at banning discrimination based on natural hairstyles, has passed in over 20 states. There's laws around pay equity and pay transparency, data privacy. And so, some states are making some efforts to ensure that there's an obligation that companies have to abide by to ensure that their workplace, as long as they comply, is an inclusive one. So just making sure that you're availing yourself of the resources that will hopefully be available.
Thank you. An anonymous attendee has a fairly mundane but important question, and I'll actually will elaborate on the question a bit. One is, does this decision, the Supreme Court decision, have any impact on an employer's ability to voluntarily ask their employees to share personal data as to their race and ethnicity, or B, to require them to share that data, typically upon entry into the workforce?
Go ahead, Lexer. You're coming from the EEOC. You can answer that.
Really quickly, well, I'll provide just a nuanced perspective. Again, going back to risk, it's all measuring the amount of risk appetite. There's no limitation, as I read and interpret the decision, on voluntarily disclosing information. Companies do that with quite a bit of frequency. I do think that there is slightly more risk for employers to require individuals to provide information that is not otherwise required by the federal government. So the EEOC does, for its purposes around investigating the workplace discrimination, require employers of a certain size to provide demographic information on an annual basis. And so many employers do so in order to comply. So there is that kind of nuance as well.
Yeah, and same for federal contractors who have to collect that data. So obviously for applicants, you can solicit that information, but it's voluntary for applicants to provide it. But it is important to solicit that information to conduct analyses on your hiring practices.
Great. So we're going to try to slide in a couple more questions, and if the panelists could take a look at the chat, I'm throwing something your way, curveball your way. So there's some people in the chat as I'm scanning here in the Q&A who are looking for more examples or details on suggestions for best practices to navigate the divide between employees who have opinions about how DEI efforts should be advanced, whether it be in your C-suite, whether it be in your Gs, and the strategic priorities of organization leaders. There's this sense of almost reflexively, hey, diversity is important. We're about diversity. That's, of course, a language given to us in large part by the Bakke decision in '78. In corporate America, in some cases haltingly, in some cases successfully, have really moved things forward. I want to give a shout out to Candy Castleberry, who's a senior executive at Amazon, currently in charge of their DEI efforts, who has introduced the concept of built-in versus bolted on in terms of what DEI or JEDI or DEIA should look like. That it's not, shouldn't be an adjunct, it should be part of the fabric of the institution. Obviously, easier said than done. But when you have a decision like this and you have a C-suite that is in disagreement, right? How do you in-house guide them on, okay, how do you actually figure out how to move forward? And this is less about the legal interpretation and more about the political judgment that every in-house counsel must have.
I don't know if anybody wants to take that. I had a quick addendum to my previous response about the data collection. I just wanted to add that, as Lexer said, for many employers, it is required to collect that data for purposes of filing the EEO-1, but it's very important that that information is not used in the consideration of making the employment decision, right? And so that information is collected, stored somewhere else, and the hiring manager does not have access to that information. So just wanted to clarify that.
There's no thoughts on the other question. We can move on to another. I would say every lawyer needs a lawyer. So find amazing outside counsel like Danielle Conley and Lathan Watkins, but in particular find outside counsel who can help you do a top to bottom review of your exit policies and offer scenarios. But most importantly, I would say find counsel not to just help you manage risk. That's your job in-house, but counsel can also help you figure out what's possible in the aspirational sense. But go ahead, Daniel.
So I think that's exactly right, Damon. And one of the things that I think, to the extent that there is that tension in the C-suite about how far do we want to go, what does all of this really mean? Do we really want to do this in this climate? A part of this is understanding, like, what's the overall mission and goals of your company, of your organization? Are you truly committed to this? And if so, you kind of got to walk the walk. And again, doing it creatively to make sure that you're not undertaking more legal risk than what you are comfortable with. But I do think sort of understanding like where the company is and what it wants to do and how valued these kinds of issues are from the very, very top, because frankly, employees in an organization know when it's not really valued because the people at the top aren't talking about it, because the policies really aren't from the top down. And so I think, like, again, a part of this is knowing your organization, knowing your company, knowing the risk tolerance and how valuable and valued these overall issues are to the organization.
Can I add to that? Oh, sorry. I'll just to mapping, right? Mapping where's the culture within your organization? Where are your employees sitting with respect to this issue? How are they being perceived? Right? This is something with DE&I. You want to continuously instill trust in your employee base and that culture. You need to be attentive to that. You also need to look at your larger customer base when you're assessing your risk. Who are the customers that you are supporting? That is providing you the profits. If you're doing things that are against or not supportive of or in alignment with what how your customers look, or even how your employee base looks, that's going to be a part of your analysis and what's your risk tolerance. And so I do think it is very important, to Danielle's point, to know your company and a risk tolerance from the C-suite standpoint, but we can't just stay in the C-suite. We need to go to the front lines and understand where individuals are and how you're being perceived, if that's your company's goal. If that is a kind of core and root initiative within your company, that's something I would suggest that you do.
Thank you. Darryl, let me come back to you. So a case that we've talked about at the Lawyers Committee quite a bit, you and Katie Euchre, who leads our economic justice team, is United Steelworkers v. Weber, 1979 case from the Supreme Court. Sean Magruder asked in the Q&A, what becomes of Weber? Should we ignore the precedent as if it doesn't exist, or should we test it? Of course, Weber is a case that holds that what the court called voluntary affirmative action programs that considerates can be permissible under Title VII in industries in which there's been a historic exclusion of people of color, minority workers, I think, in policy. But Darryl, what becomes of Weber?
Weber is still good law. And in my personal experience, and it's been a while since I was in private practice, right? So Danielle could probably speak better to this, but at that time, there were employers who were interested in, determining whether or not they could satisfy the requirements under Weber. And that requires a very close analysis in consultation with outside counsel, right? And so I think to the extent that, and Danielle, correct me if I'm saying anything wrong here, but I think for employers who are interested in exploring that they should have that conversation with counsel to see if they would meet the criteria under the Weber exception.
Great. I'm going to do rapid fire here just to get as many questions in as possible. Audience, we're going a little over time with the agreement of our panelists and our gracious host at ACC Foundation for another 5 to 7 minutes here. So an anonymous attendee, and I'm glad it's anonymous, asked what I will call a hypothetical question, and your answers can be not legal advice, but just a hypothetical response. The question is as follows. While we have a goal for employment of women and minorities of 50% by 2030, we tell hiring managers to hire the best candidate for the job. Does that advice to hiring managers insulate us adequately from claims of preferential hiring?
I'm not going to directly answer the question, but I did want to raise, and maybe we could have a part 2, but there was this piece in the opinion about, in the Chief Justice's opinion about data and the importance of disaggregated data. And I just wanted to flag that because I do think it's important for businesses. The question was framed in terms of minorities and women, right? And I do think it's important to, when possible, do a more detailed analysis that doesn't look at minorities overall, but that looks at, Hispanics specifically, Blacks, Asians, et cetera, to better understand what's going on within each of those particular groups.
I also want to remind us, I appreciate that, Darielle, but I also want to remind us that those two things are not necessarily mutually exclusive. So having a diverse pool and having diverse workforce, is not necessarily inconsistent with having the best people there for the job. However, when you are talking about goals, and this is common knowledge, we want to make sure that we're talking about them in an aspirational way. So I don't know if that adjective was added to the question, but we want to make sure that, I'm sure when you seek legal advice from outside counsel or your in-house counsel, they will remind you of this, that we should be thinking about, goals in a much more, aspirational way rather than hard and fast targets or quotas, if you will.
I think that's right. And again, it's all a matter of how much risk you want to take on. And it is much riskier when you have a hard target that is, we will hit 50% women and people of color by 2030, because courts will look at that as evidence that hiring managers were at least encouraged to use race or gender in making hiring or promotion decisions. So again, it's a spectrum of risk. And like Lexer said, if you're going to have goals in that way, they should be much more aspirational and less, it's potentially sort of things that look like quotas.
Right. That's what I was going to say. That is quota quintessential, right? So I think the aspirational language is important. Back to Lexer's comment, right? The myths of application of affirmative action, that was something I wanted to bring up before, like this dichotomy of if they're diverse, then they're not qualified. Application of affirmative action starts at the baseline of having qualified candidates. That's the baseline, right? You build from that. All of the candidates are qualified. Now you're assessing, is there underrepresentation in a particular job, industry, or area by which, having all things being equal, we would select a candidate that has an affinity that has not been represented in this particular instance. And if you put a scenario in place, we're talking hypotheticals, HR, we know HR is predominantly female, right? If you have 2 qualified candidates and then you are interviewing and you want to kind of diversify that predominant female base in an HR group, you selecting a male candidate for that position would be affirmative action applied, and that would be applied in a legally enforceable fashion.
Great. We do have to start to close out. I did want to ask one more detailed question before we have closing remarks. An anonymous attendee asked about the potential impact on Black entrepreneurs, such as the 15% pledge, which in part calls for retail companies in the retail industry to have shelf space dedicated to Black-owned brands. This was something that came out in 2020, I believe, after George Floyd's murder, kind of part of the corporate community's response. Do you expect that kind of plan may be vulnerable to attack if a corporation avowedly try to adhere to or fulfill it?
So again, I think this is a place where it depends on how they do it. If ultimately they do it by saying, in order to get Black businesses in the door, we are going to contract with them and give them additional benefits and a lower discount rate to come put their stuff on our shelves than we would to white business owners, I do think that could be a potentially strong case under Section 1981, which again prohibits discrimination on the basis of contracting. And so I would be concerned about that. But if the idea is that we're going to try and recruit as many Black businesses as possible, and so we're going to like hit the pavement and do whatever we can to like make sure they know about our business, make sure they know about the opportunities, again, expanding the pipeline as opposed to making specific contracts that give benefits to Black businesses in a way that it wouldn't to white businesses, then, you know, I think it's legally safer.
Yeah. Look, we have to close out now. I'm going to offer you a chance to offer a top 1 or 2 takeaways that you want the audience to walk away with. Danielle, I know you're on the clock, so I'll start with you first.
I think top takeaway really is, you know, even if this decision discouraged you in the sense of, oh my goodness, is this going to hamper our DEI efforts? Really not to look at it that way, but to look at it as more of a challenge of ways to be more creative in what you're doing, more thoughtful in what you're doing, really thinking about what your goals are and sort of a legally sustainable way to get there. And so my big takeaway is, you know, work with your in-house counsel, you know, work with outside counsel to come up with programs that really are legally sustainable, but that don't really take your foot off the gas on DEI efforts in the workplace because they're so important.
Thanks so much. Tanya.
I would just add to work for all your DE&I efforts. One, continue them because this decision does not impact them in the sense that you need not pursue them. It just changes the way in which you pursue them and makes for you to have a more refined and a need to partner with your legal counsel externally and internally to ensure that your programs are withstand any scrutiny that we already know is going to come given this particular decision.
Thanks, sir. Thank you, Tanya.
Partnership is key. Tanya said it. Regular and open communication with your in-house colleagues. For those of us who are in-house, you know, regularly communicating with your HR colleagues, your DEI or IDE colleagues, to ensure that, you know, everyone understands the current landscape. And then also reaching out to outside counsel regularly, early on, not when things hit the fan, but on an ongoing basis. So communication at regular intervals, I think, is an important part of the partnership.
And Dariella.
I'll just close with, you know, another call to action that DEI in the workforce is still very, very necessary. We know that Black workers are underrepresented in the lowest paid jobs and overrepresented in the lowest paid jobs and underrepresented at the highest levels of corporate organizations. So it's critically important that, as folks have said, you keep your foot on the pedal and continue with these efforts. They are critically important for our communities and critically important for our economy.
Thanks so much. Please thank our panelists, Dariella Rodriguez, Danielle Connolly, Lexer Kwame Mayers, and Tanya Blocker. And I am Damon Hewitt, President and Executive Director of the Lawyers Committee for Civil Rights Under Law. Thank you for joining us today. Thank you to Jen Chen and the entire ACC Foundation team for being wonderful co-hosts and offering this space. I'll place in the chat some links to resources. My takeaway is to get the best advice possible and think in terms of possibility. As we said, the day the decision came down, no matter what this court holds, we have a lived experience in reality in colleges and universities, in the workplace, and in our communities, that at the end of the day, nothing is going to take away the fact that we have a race-conscious future. The question is exactly how do we do it in a way that sees, identifies, and values all of us as contributors, not a human hierarchy, but part of a human family. Thank you so much. Good luck with everything, and reach out to us if you have other questions. Appreciate you.
Thank you, everyone.